Okay, let's go on the record on cause number DC2019244. Council, make your appearances.
Your Honor, Jessica Lynn Sepulveda for the plaintiffs Ramirez and Pacheco.
Your Honor, Dan McLean for defendants William Langford and MOA Electric Inc.
And Victoria Niave, guardian ad litem for minors NP, MP, and JP.
Okay. We've had a brief discussion off the record about putting this on YouTube. The parties have all agreed there's not going to be anything sensitive put on here, but if there is, we'll either stop the YouTube or take it down. So, subject to that, we'll go ahead and proceed. You may proceed, Ms. Sepulveda.
Yes, Your Honor. At this time, I'd like to call Ms. Maria Ramirez.
Okay.
Yes.
Ms. Ramirez, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And before we start, is there a proposed judgment on this case that's been submitted?
Not yet, Your Honor. My understanding is that Ms. Clara Tillman will have that on file with the court max within 2 weeks. Is that okay, Dan, to say?
Yes, that is. That's fine. And Clara's aware of that.
Okay. Okay. Let's go ahead and proceed.
Ms. Ramirez, you have now just placed your name and oath before the court. Can you please say your full legal name for the court?
María de Jesús Ramírez Gómez.
And Ms. Ramirez, you have brought a lawsuit for the minor children of Nicholas, Miguel, Maya, and Julian Pacheco in regards to a motor vehicle accident for personal injuries that occurred on May 20th of 2019. Is that correct?
Yes.
And yourself as well, you brought an individual lawsuit for personal injuries for yourself as Maria Ramirez. Is that correct?
Yes.
And can you state for the record the nature of your relationship to Nicholas, Miguel, Maya, and Julian Pacheco?
I'm the mother.
And are you the current custodial and biological mother of Nicholas, Miguel, Maya, and Julian Pacheco?
Yes.
At the time of this accident, were the ages of the minor children in which we are here for today, Nicholas, 11 years old, Miguel, 9 years old, Maya, 6 years old, and Julian, 2 years old?
Yes.
Would you please briefly tell the court the nature of how this motor vehicle accident occurred?
Yeah, I was coming from my house to my work, and I was coming from the service road to La Prada, and on the right side, the bus, public bus stopped, so everybody shifted to the left, and the third car in front of me stopped, the next one stopped, I stopped, but the car behind me couldn't stop because it was like pulling a trailer. So hit me from behind and pushed me to the car in front of me. The back window shattered. My kids started screaming. The baby started crying. I was numb for a little bit. I turned my head to my left because I saw somebody on the window, and I was the driver of the car. So he started saying, "Why you stop? Why you stop?" And when he saw my kids crying, he's like, "Okay, is everybody okay? Is everybody okay?" And I was trying to calm my kids because they were crying.
So, Ms. Ramirez, this is a rear end collision, is that correct?
Yes.
And the vehicle that was driving the car that rear-ended you, the individual's last name was Langford, and he was driving a company vehicle, is that correct?
Correct.
But this was not a larger vehicle in which it was an 18-wheeler or a semi-truck or anything of that nature. Is that correct?
Correct.
And in regards to the rear-end collision, there were injuries that occurred to yourself as well as to the 4 minor children. Is that correct?
Correct.
And in regards to this personal injury case, you did hire an attorney. Have you had an attorney for the entirety of this case?
Yes.
And who was the attorney that has represented you through the entirety of this case, Ms. Ramirez?
Attorney Sepulveda.
And I have the following injuries for your minor children from this accident, which we're here for today. Nicholas, right elbow pain. Miguel, neck and shoulder pain. Maya, abrasion to her lip. Julian, the youngest, excessive crying, but no abrasions. Is that correct?
Correct.
And because of the injuries that you believe they had, all three of your minor children did receive one ER visit as well as some chiropractic treatment. Is that correct?
Correct.
And the youngest minor did receive a couple of chiropractic treatments. Is that correct?
Yes.
In regards to all of your children, none of the children thankfully had any findings such as broken bones or ligament tears or any herniations or anything of that nature. Is that correct?
Correct.
And although they had bruising and had some mental effects from the accident, at this point here today, all of your minor children, Nicholas, Miguel, Maya, and Julian, are all recovered from the accident. Is that correct?
Correct.
And all of the children, Nicholas, Miguel, Maya, and Julian, the treatment never exceeded a period of time of over 2 weeks. Is that correct, Ms. Ramirez?
Correct. Yes.
And it's your understanding that we're here to settle the minor's case against the defendants. Is that correct?
Correct.
And were you able to participate with counsel through the entirety of the mediation in which a settlement offer was placed and accepted?
Yes.
And did you understand the entirety of that session and willingly agree to the amounts for the settlements for those minor children?
Yes.
Is it your understanding of the settlement terms of against the defendants and for the minor children that the following settlements are for Nicholas, Miguel, and Maya Pacheco, $5,000, and for Julian, $3,000?
Yes.
Is it your understanding that the settlement is all the money in which the defendants and their insurer will pay your minors as a result of this accident?
Yes.
Have you determined where you are to place the money for this minor children's after the small amounts paid to the medical providers and reduced attorney's fees? Is it your understanding that those sums of money for the minor children will be placed with the court registry?
Yes.
Has that been explained by your counsel as well as to the ad litem as to what the nature of that means, the minor children's monies being placed with the court registry?
Yes.
Are you voluntarily entering into this settlement agreement today?
Yes.
Ms. Ramirez, if you can agree as I go through each breakdown for the minor children. For Nicholas Pacheco, there is a settlement amount, as we've stated, of $5,000 with the medical expenses reduced down to $1,010. Attorney's fees have been reduced down to 30%. The court costs have been waived in the entirety for the minor child, which is going to allow for Nicholas to have in his pocket $2,489.90. Is that correct?
Correct.
For Miguel Pacheco, with a settlement amount of $5,000, with his medical expenses reduced down to $940.10. Attorney's fees reduced to 30%. Court costs have been waived in its entirety, with the in-pocket to Miguel of $2,559.90. Is that correct?
Correct.
For Maya Pacheco, with a settlement amount of $5,000, with her medical expenses reduced down to $960, attorney's fees reduced down to 30%, court costs waived in its entirety, with an in-pocket for Ms. Maya of $2,540. Is that correct?
Correct.
For Julian, for a settlement of $3,000, with a medical expenses reduced down to $320, the attorney's fees reduced to 30%, court costs have waived in its entirety, with the in-pocket for Mr. Julian of $1,480. Is that correct?
Correct.
Do you believe that it is in the best interest of all minor children to settle this case with the accordance of the terms in which I have just outlined?
Yes.
Do you understand that by settling this case today, by not settling this case today, you would have been entitled to a jury trial against the defendant's case?
Yes.
Do you understand that by taking a jury trial that you could have been awarded less than, more than, or none at all in regards to the motor vehicle accident for the minor children?
Yes.
Do you understand that by accepting this settlement today, any existing injury, the minors, and any injury which may arise or develop in the future would not be compensable or recoverable from either defendants or their insured?
Yes.
Ms. Ramirez, based on all that we've set forward in the record today before the court, do you still want the judge to approve the settlement as which we have outlined for Nicholas, Miguel, Maya, and Julian Pacheco?
Yes.
Your Honor, I pass the witness.
All right, Mr. McLean.
Just briefly, Your Honor, and thank you, Jessica, for covering all that. Ms. Ramirez, can you hear me, ma'am?
Yes.
All right, so you know, I am one of the attorneys involved in this case representing Mr. Langford. That's the driver of the other vehicle, so you understand that's who you've sued in this case?
Yes.
And have you been satisfied with the services of your attorney in this case?
Yes.
Have you been satisfied with the services of the guardian ad litem in this case?
Yes.
And do you believe that the settlement as recounted by Ms. Sepulveda is in the best interest of your children?
Yes.
And again, you agree with the settlement, correct?
Yes, correct.
And do you realize that even beyond this agreement, should the children become worse or develop something later regarding this accident, you cannot come back into court and file another suit because of that? Do you realize that?
Yes.
And do you understand that the monies as described by Ms. Sepulveda is all the monies that you will be receiving, or the children, on behalf of the children, will be receiving as a result of this motor vehicle?
Yes.
All right. Thank you, ma'am, for your time this morning. I will pass the witness.
Ms. Nieve, before you move forward, I apologize, Your Honor. I have one more thing that I'd like to place on the record.
Okay.
Ms. Ramirez, is it your understanding that prior to today's hearing that there was a lien that was placed on Nicholas, Miguel, and Maya Pacheco for White Rock Lake Hospital?
Yes.
And is it your understanding that today that lien has been released and there's not any amounts owed to City Hospital Dallas White Rock for Nicholas, Miguel, and Maya Pacheco?
Yes.
Thank you. I pass the witness, Your Honor.
Okay. Ms. Nieve.
Thank you, Your Honor. Good morning, Ms. Ramirez.
Morning.
My name is Victoria Niave, and you recall that I visited with you on the phone about the incident that your children were involved in, correct?
Yes.
And I also had a chance to visit with your children virtually and talk to each of them about the case and the injuries that they sustained in the case, correct?
Yes.
And you understand that I do not represent you, correct?
Correct.
And you understand that I was appointed by the court to represent the best interest of your children, correct?
Yes.
And did I answer all of the questions that you had or that the children had?
Yes.
Okay. Thank you. Pass the witness, Your Honor.
All right, Ms. Ramirez, do you have any questions for me?
No.
How are your kids doing now? Are they having any problems from the accident, or are they recovered?
No, they're recovered. Sometimes they have nightmares, but it's like here and there.
Okay. Okay. Do you want to go ahead and settle this for your kids?
Yes.
Okay. Is there a recommendation of the guardian ad litem?
Yes, Your Honor. I respectfully request that the court approve the settlement as in the best interest of the minors. I had a chance to visit with them, talk with them, review records, and believe that the funds being deposited into the registry of the court is in their best interest, and request the court's approval.
Okay. The court is going to go ahead and approve this settlement. Thank you, Ms. Nieve, for your service today. Is there an agreement as to the amount of the guardian ad litem fees?
We're going to,
Mr. Martinez. Sorry.
and then we'll.
Yeah, you cut out for a second. I apologize.
Sure. I'm going to be submitting my billing records to defense counsel, and we will submit an agreed amount in the final judgment, Your Honor, if that's okay.
That's fine with me.
Okay. All right, well, as long as there's an agreement, I guess, Mr. McLean, if there's some kind of issue, then feel free to set another hearing on this.
Yeah, I'm sorry, Ms. Tolman would be doing that, but I'm sure it's fine. She's aware of that situation as I understand. So with the, there shouldn't be a problem with the guardian ad litem fees that I'm aware of.
Okay. Sounds good. Anything else today?
Just one thing, Jessica, if you don't mind, I had trouble getting all the numbers because you're reading kind of fast, which is fine. Can you just follow up with Clara Toman with the final breakdown on those numbers that you had? Because we'll be preparing the final documentation, and we want everything to be correct and accurately presented to the court for the final judgment. Do you mind doing that?
Yes, of course.
Right. Thank
No
you.
problem.
And I'll let her. All right. Thank you.
And I will commend you, Mr. Pulpita, for agreeing to reduce your fees and waive your court costs. On behalf of the minor, it's always helpful to get these cases settled. We always want to do what's in the best interest of the minor. And Ms. Nieve, again, thank you for your service to the court and getting this done. And you guys are excused. You guys have a great day, okay?
All right. Thank you, Judge.
Here, everyone.
All right, Mr. Jackson, Mr. Thornton, what are you guys here for?
Your Honor, I'm here for Gabrielle Mack.
Let's see, is this on the scheduling conference docket?
It's a hearing on intent to dismiss.
Gabrielle, was this on the DWAP docket at 9?
Oh, yes, Your Honor.
Okay, sorry. Let me pull that up real quick.
No, that's completely my fault.
It's okay. Let me look it up. Gabrielle Mack. Yes, nobody showed up for that. What's going on with that one?
I'm honestly not sure, Your Honor. The intent to dismiss was because we hadn't obtained service on one or more of the defendants. And I mean, as far as I'm aware, there are only 2 defendants in this case, and they both filed answers as of July.
Okay, let me take a look at it. Mack versus Mattal. I don't see anyone's filed an answer. I'll share a screen. You can take a look at it.
Okay.
I don't see an answer.
Your Honor, I'm looking at the district clerk's website, and I can see where both defendants have filed an answer. What can I do to reconcile that discrepancy?
I mean, this is what I'm looking at is Odyssey, which is the same as the district clerk's website. I don't know. Never had anyone say that before.
Let's see.
Are you sure you're looking at the right case?
Gabrielle Mack, DC 0. No, this is a different cause number. That may be the issue.
Okay. So what's going on in this case then? Do you know?
That is a good question. Do you mind if I take 5 minutes and take a glance at that one?
Sure, no problem.
Thank you.
Okay. Why has this been difficult? All right. Ms. Henke, what are you here for?
Good morning, Your Honor. I am here on the Adams versus Vu et al. Cause number DC 2017490.
Okay.
There's an unopposed motion for special setting the plaintiffs filed, as well as a scheduling conference.
Adams v. Doe, is that it? Okay.
VU.
VO,
Yeah.
okay, VU, okay. Sorry, it's a little confusing how this is done. Okay. But I guess everyone's not here yet. Is that right?
I think, I don't see plaintiffs' counsel yet, but I know Mr. Thornton is here. And then Ms. Cashin, are you here as well?
Yes, I'm here.
So we're still missing the plaintiff's attorney. It's not 10 o'clock yet, so I'm not.
I see Mr. Cars, but I don't, well, I see his name. I don't see him. I don't know.
Okay, so this was transferred to us, it looks like. Is that right?
There is the defendants have filed motions to transfer venue.
Okay. Not denied them.
I don't believe they've been set for hearing yet.
Okay. Okay. Here we go. All right. And is the plaintiff's attorney here on that case yet or no?
I believe Mr. Fechner just arrived.
Hello, Mr. Fechner.
Good morning, Your Honor.
Good morning. Everyone here that needs to be here on Adams v. Vu?
Everyone's here on the plaintiff's side, Your Honor.
Everyone here on the defense side?
I believe so, Your Honor.
Okay, so we're here on a scheduling conference docket. Ms. Henke mentioned that you guys may want to have a special setting on this case. So why don't we talk about that and kind of figure out what's going on with the case and how we can get you guys accommodated, okay?
That's great. And Chris Carr has joined me in my office. His audio is not working in his, so
Sorry, Your Honor.
That's okay.
So this case is Jesse and Rich Adams are the plaintiffs in this case. Mrs. Adams went in for an ESI procedure in 2019 and left paralyzed from the chest down. She's been paralyzed and hospital bed bound since that day, and her husband, Rich Adams, is her full-time caregiver. As you can imagine, it is very difficult for her to travel outside of her home, especially for extended periods of time. This trial we anticipate to be several days. She intends to testify, her husband intends to testify, and during that time, they're going to need additional caregivers to provide assistance. And so we would like a special setting so that when they do have to appear and testify, they only have to do it once. There's no uncertainty about, are we going to go this week, next week, is it going to get bumped? And so we think that this case is right for a special setting. The defendants are unopposed to this request. They recognize the difficulty faced by the plaintiffs in this case. And so we'd respectfully request a special setting.
Yeah, that sounds very reasonable for a special setting. How are you guys coming on discovery? Are you guys almost done, or it's a 2020 case? So
the parties have all responded to written discovery.
Okay.
The next step is likely depositions and experts. In terms of a trial date, we would like to do this sometime between July and September. Plaintiffs prefer the earlier time frame, while defendants have requested September 27th. That's the trial setting. The only 2 weeks that the Adams are unavailable are the last 2 weeks in July, but otherwise, anytime between July and September for a special setting works for plaintiffs. And I think that we can work with defendants to work out a discovery schedule and all other disclosure deadlines based on that time frame.
So let me just give you real quick the standard speech I give for special settings, and then I'll kind of add a COVID overlay, but hopefully by July that won't be an issue, but who knows? And so I'm happy to do a special setting on this. It sounds like the type of case that needs a special setting, so I don't have any problem with the idea of doing a special setting. I will say I've had this typically happens on these catastrophic personal injury cases where people have requested special settings, but then they didn't get their discovery done in time. And so they asked for a continuance in another special setting. And essentially you get one shot at a special setting, you're kind of set in stone. And so I'm not opposed to specially setting you, but I'm a little worried that that's kind of quick if you have a lot of discovery left to do in terms of depositions, experts, all that kind of stuff. And so that would be my main concern. It's just this is, you know, relatively quick for a case like this. And are you sure you can finish your discovery in time?
We feel confident that we can. Defendants have represented that they feel confident that if it's a September 27th trial setting, they can as well. And while we would like the earlier, I understand the judge's concerns about making sure that we're not coming back to the court again. So the plaintiffs will agree to a September trial setting if that's what it takes to get a special setting.
Let me just look up one thing. Let's see. I'm just looking at, I'm trying to find out when the bench bar conference is in 2022. It doesn't seem like it's out yet. I
think it's usually October.
Yeah, it sometimes, yeah, I heard what you guys said. Sometimes it's late September. This year it was later, it was late October. I might suggest maybe a little bit earlier in September, just in case. I just don't, and if anyone wants to look it up, I can't find it right now, but if you guys want to look at it, I'm happy to.
I'm looking real quick to see if I can find it. It probably isn't listed yet.
Yeah, it might be out already because we set our jury trial docket according to the bench bar schedule, and so that should be coming out. So they should be coming out with a date pretty soon, but
I don't see it on their calendar yet. I think a mid-September or earlier September trial date. I feel confident we can get discovery done. I don't think 1 or 2 weeks is going to cause too much heartburn in that regard. The schedule, the discovery schedule that we talked to the defendants about would largely be unchanged based on any trial setting in September. So I think any time in September would work.
And Your Honor, just as a caveat with that, I think the mid-September would probably be preferable by defendants, just for it to be a little later, but also I know Ms. Hermes, who's one of the attorneys from our office, is taking her firstborn to college at the end of August. And so I know that probably mid-September would be preferable just from a pretrial deadline schedule and whatnot, but we can work with.
This is strange. I have a ton of cases set on September 6th. I'm not sure why. Of next year. That's weird. We have like 23 cases set already, but then the next week we only have 6. So not sure how that happened exactly, but so I wouldn't do the first week probably. So maybe how does September 13th look for everybody?
That'll work for plaintiffs.
That's fine, Your Honor.
Did everyone say yes? I couldn't hear.
That'll work, Your Honor.
Okay.
I believe that'll work for us as well.
Okay. And then let's chat real quick about mediators in this case. Who do you guys want to use as a mediator?
We proposed Judge Ashworth, and we haven't really had too much substantive discussion about mediators yet. I think the defendants have proposed Dan Marley, who plaintiffs are opposed to, but I don't know if defendants are opposed to Judge Ashworth or not.
Are you guys opposed to Judge Ashworth?
Your Honor, just with the basis of the case, I think that we want a mediator who has a lot of experience with med-mal cases. So I know, we were going to propose either Mary Burden or Jim, I'm going to butcher this last name, Juno.
Jim Juno, yeah, Jim Juno.
So I don't know if plaintiffs would be open to either of those, but we're obviously willing to have a discussion about that.
Yeah,
those are both very good mediators. Mary Burden is, I think, cutting back a little bit on her mediations, but but I'm sure she could get one done by next September.
Okay.
Your Honor, plaintiff would be fine with Jim Juno.
Jim Juno, does that work for you, Mr. Thornton?
Yes, sir.
And Miss Cashin?
Yes, sir.
And I see Ms. Henke, since you suggested it, you'd be okay with it. So
yeah. Yes,
then we'll go ahead and appoint Jim Juno. And understand this, just, it's not an excuse that you haven't, if you want a special setting, which I'm okay with doing, it's not an excuse to get a continuance from a special setting that you haven't finished discovery or you haven't gotten a mediation done. And so are you 100% sure you want to specially set this?
We are, Your Honor.
Ms. Henke?
We're fine with that, Your Honor. We're unopposed to the special setting.
And Ms. Cashin, Mr. Thornton?
We're unopposed, Your Honor.
Same here, Your Honor. No problem.
Okay. Good luck with getting all of this done. And we will go ahead and specially set it, and we'll appoint Jim Juno to be the mediator. Anything else today, guys?
That's all for plaintiffs, Your Honor.
And I assume you guys will submit an agreed scheduling order, and we'll just go ahead and set this for trial. Then we'll send out notices this week.
We will do that this week, Your Honor.
Yes,
all right.
sir.
Thank you so much, guys.
Thank you, Your Honor.
Thank you.
You are excused. Give me 1 second, everyone. All right. Were you able to find out?
Yes, Your Honor. Or I assume you're addressing me, Your Honor.
Yeah.
Yeah, yes, sir. So apparently this suit was filed in error. A duplicate suit was filed. So if you will just give us a 30-day continuance, we will have the improper one disposed of by the next setting.
And which cause number was this? Was this DC 215855?
Yes, Your Honor. And a duplicate suit was filed in Judge Whitmore's court. So
which one was filed first, mine or hers?
The one in Judge Whitmore's court.
Well, do you want to just DWAP mine then?
Yes, Your Honor.
Okay, we'll just go ahead and DWAP yours then.
Okay.
Yeah, in that situation, which is not a right thing to do, but it's going to look like forum shopping if you choose the second judge. So I don't want to get Judge Whitmore upset with me. So, or you. So yeah, go ahead and we'll DWAP my case, and you can go forward with hers. So, all right. Thank you so much.
Thank you for your patience, Your Honor.
No problem.
Bye.
Hey, let's go off the record real quick.